Question number 12. What are the essential elements of vicarious liability illustrated with case law? Then question number 13. Relationship of master and servant is an essential precondition for determining vicarious liability elucidated. Explain the term vicarious liability. What are the modes of vicarious liability? And question number 15, discuss the liabilities regarding the relations between servant and master under the law of tort. So, regarding this, vicarious liability is determined on two tort maxims. One is qui facit for alium facit por se, which means he who acts through another is damned in law is doing himself. And the second maxim that determines or governs vicarious liability is respondent superior. It means the superior must be responsible or let the principal liable. So, vicarious liability in regards to master and servant relations. Here, two questions were raised in the leading case of Amrit Singh versus the Union of India in 1973 by the Supreme Court. Who is a servant and what is in course of employment? And these two questions were answered in the leading case, that is Shyama Devi versus State Bank of India in 1978. Supreme Court expressed that regarding the very fact of the case, the plaintiff's husband gave certain amount of money and a check to one of his friends in his house to deposit in his account, and the friend was an employee of the State Bank of India, and that friend did not give any receipt or acknowledgement of the amount he has taken to deposit in his account. And by the way, when he did not deposit the amount, then the plaintiff moved to the court, and regarding that, the Supreme Court expressed that as the friend at the time of receiving the amount and the check was not acting in the very course of employment of the bank, neither at that time he was also a servant of the bank, so the bank was not liable. And regarding that very principle of vicarious liability, two theories are developed. One is the control theory, and the second one is the contract of service. And by opposing the very control theory, Lord Thankerton invented the contract of service theory, and in that contract of service theory, he expressed that the very employment conditions and the very selection of the servant is based on contract of service, and which is more important than the controlling of the servant, which is the foundation of control theory. And regarding that, we will discuss another important leading case, that is Anandan versus Amalai in 1988. The Kerala High Court expressed that the plaintiff gave his car to be repaired in a workshop, and from it, it is presumed that he must have given his permission regarding test drive of the car after the repair, but there must be the very specific limit of the authorization, and if it is not within that limited authority which he permitted, then the defendant would be held liable. Otherwise, the defendant would not be held liable if during the test drive any accident occurred by the workshop repairing driver. So, this is all about the very principle of vicarious liability that is governing the relationship of a special nature between the master and servant. And now we will discuss regarding the very question that is discuss the rule of reliance versus pleasure, with the exception to the rule as this question was asked under question number 8, and regarding that there is the very meaning than the principle that was determined in the very case reliance versus pleasure, that if anything escape and that is dangerous, and if it is collected and kept in one's land and which likely to do mischief, and it must be non-natural, and in that case the very defendant is answerable for all damages caused, and such dangerous things collected and kept in one's land could be such as gas, oil, electricity, noxious fumes, poisonous vegetation, or even a flagpole, etc. So, regarding that, we will discuss a leading case, that is Bal Krishnan Menon versus Subramaniam in 1968, and the very fact of case that the defendant used certain explosive items in an open field on the occasion of a festival, and that is a non-natural use of the land, and if such use, if it accepts and caused any mischief, then it would be held as strict liability, or as it was held in the very principle of strict liability in the leading case reliance versus pleasure. And in another important leading case, Green versus Chelsea Water Works Company in 1884, Lord Justice Lindley expressed that the very escape of such dangerous things must be from the land, and there must be non-natural use of the land, and the very exceptions that we found, that things naturally on land and which escapes and caused any damage would not fall under the principles of strict liability, and such as the very vegetation of thistles which automatically, naturally, they spread to other parts of the land. And another one is that consent of the plaintiff in that case, in the upper floor of the building, a water box was placed with the very consent and knowledge of the plaintiff, who is residing under the ground floor, and that water box pipes were burst and the water escaped and it caused damage to the plaintiff's good on the ground floor. So here, as the plaintiff gave his consent on setting the waterworks on the rooftop, so here the defendant would not be held strictly liable so where there is the default of the plaintiff. So when a defendant or the plaintiff trespass to the land where such dangerous things are collected and kept, and if it caused any mischief, then the very plaintiff would not be, the defendant would not be held liable, as it is the very default of the plaintiff. And so also another exception is act of a stranger. So whenever at the top floor a waste pipe and water taps are plugged off with malicious purpose by a stranger or a third person, then the defendant would not be held liable, as the very act was done by a stranger or a third person. And the next exception is act of God. So under act of God, all the natural calamities such as thunderstorm, earthquake, flood, etc. are falling, and if any damage caused due to act of God or due by natural consequences, then the defendant would not be held strictly liable. So also the very concept of another exception is regarding certain statutory authorities who were empowered to enter into the premises and to do their official duties or activities as prescribed under this statute, and if it caused any mischief, then it would not fall under strict liability. And regarding that, we would like to discuss two Indian leading cases. One is MC Mehta versus Union of India 1987, and the Bhopal gas tragedy or leak case, where our apex court, the Supreme Court, held that strict liability is no doubt is the very responsibility of the defendant, and in spite of that, the state would have to bear equal responsibility and to provide equal compensation to the persons who were affected under the very principle of strict liability. So here, besides the defendant, state was also held to be liable equally and to provide compensation to the affected person. So the very principle of absolute liability was developed by the Indian Supreme Court in the very important leading case MC Mehta versus Union of India in 1987. So also in the Bhopal gas leak case, which besides strict liability, they evolved the very principle of absolute liability. And regarding all these questions and their answer, already we have uploaded many videos in our previous editions, and that one can follow to find out the correct and the sufficient answers regarding these questions.